The first part of this presentation provides a broad overview of the process by which the PSC sets rates for utilities within its jurisdiction. It applies to electric utilities, the largest natural gas distribution companies, to water utilities, and to sewer utilities. Some small utilities are eligible to use a simplified and streamlined version of this process. The second part of the presentation provides an overview of the pending rate adjustment application of the Big Rivers Electric Corporation. As with other matters under PSC jurisdiction, rate making is a legal process. It is governed by statutes enacted by the Kentucky General Assembly and by PSC regulations derived from those statutes. Also applicable are legal precedents set forth in earlier PSC orders and in court decisions regarding the application of PSC statutes and regulations. The guiding principle in Kentucky statutes regarding rates is that they must be fair, just, and reasonable. Those terms are not defined in law, but their general meaning has been established over time through precedents and legal interpretation. In applying the statutes, the PSC seeks always to strike a balance between the interests of the utility and its customers. Because they do not have shareholders, cooperatives do not earn a return on investment. However, they are granted rates that produce revenue in excess of expenses. This is so they can maintain financial stability and meet financial requirements set by the entities that extend them credit. Determining rates is a two-part process. It involves calculating a revenue requirement and then establishing a rate design. Let's look at those parts of the process in detail.
But first, let's look at how the process works. Utilities must give the PSC at least 30 days notice before filing an application to adjust rates. They also must give public notice to their customers when the application is filed. The procedural clock starts running when the application is filed and determined by the PSC staff to meet all filing requirements. An application cannot be acted upon until it is complete. The applied for rates cannot go into effect until 30 days after the application is filed. However, in practice, the PSC may, and usually does, suspend the rates for 5 or 6 months to allow for a thorough review. If the PSC does not issue a decision before the suspension period ends, the utility may put the rates into effect pending a final decision. But if the PSC ultimately grants rates lower than those requested, the utility must refund the overcollection to customers with interest. The PSC has 10 months from the time the application is filed to complete its consideration of the rate application. Once a final order is issued, any requests for reconsideration must be filed within 23 days of the order. Interveners are parties other than the utility that play a formal role in the proceedings before the PSC. By law, only the Kentucky Attorney General has the absolute right to intervene in cases before the PSC. Kentucky statutes designate the Attorney General as the representative of ratepayers as a whole. Other parties may petition the PSC to become interveners. In order to be granted full intervention, a party must show that it represents a unique interest not represented by the Attorney General, and that it will be able to bring forth evidence that might not otherwise come to the attention of the PSC. Parties granted full intervention are allowed to introduce testimony, ask written questions of the applicant and other parties, and participate in the cross-examination when the PSC holds its formal evidentiary hearing in a case. Examples of parties granted full intervention include groups representing interests such as large industrial customers, low-income residential customers, and local government or municipal entities. The PSC on occasion grants limited intervention. Limited interveners participate in the hearing, but do not present evidence, put on testimony, or engage in pre-hearing discovery. Parties may seek intervention once a utility gives notice that it will file a rate application. The application includes direct testimony by witnesses who will appear at any hearing held by the PSC. Just like direct testimony in a court proceeding, this pre-filed testimony is taken under oath and any perjury is subject to the penalties under the law. The same is true of any testimony filed by interveners. After the application is filed, there may be one or more rounds of written questions, known as data requests, between the parties. The PSC staff also files data requests. Responses to data requests are made under oath. The PSC is not required to conduct local meetings solely for the purpose of taking public comment, but may do so at its discretion. With or without public meetings, public comments are always welcome and will go into the case record for the Commission's consideration. They may be submitted by mail, fax, email, or through the PSC website. An evidentiary hearing is not required but is customarily held in major rate cases. It is conducted much like a court proceeding. Although testimony is usually filed in writing in advance, witnesses appear under oath and are subject to cross-examination by counsel for other parties, by the PSC staff, and by the commissioners themselves. In complex cases, hearings may last several days. All PSC hearings are open to the public and are webcast on the PSC website. After a hearing is concluded, the PSC may ask for additional evidence or for briefs from the parties summarizing their positions. The PSC then takes the case under advisement. Decisions are rendered in writing in the form of a final order. A decision requires agreement by at least 2 commissioners. Cases sometimes are settled in advance of the PSC hearing. When that occurs, the PSC will conduct a hearing on the proposed settlement. In order to be considered by the PSC, a settlement must be unanimous. In other words, all parties to the case must agree on all the issues in the case. However, partial settlements, known as stipulations, are permitted. In such cases, all parties agree on one or more issues, leaving the remaining issues to be decided by the PSC. Settlements typically set forth a final result without detailing the compromises involved in reaching that result. For example, a settlement often will produce a proposed rate structure without providing the underlying calculations by which it was derived. However, in order to accept a settlement, the PSC must still evaluate the final rates, and they must meet the test of being fair, just, and reasonable. The PSC has the right to accept, reject, or modify a settlement. Now let's look at the 2 fundamental calculations used to determine rates. The revenue requirement is the total revenue a utility needs to maintain safe and reliable service and financial stability, and, in the case of investor-owned companies, offer its shareholders the opportunity to earn a reasonable rate of return on equity. Revenue requirement is based on a 12-month period known as a test year. If it is a backward-looking or historic test year, the 12-month period must end no more than 3 months before the filing date of the application and uses actual financial information for the period. Forward-looking or forecasted test years are prospective 12-month periods that begin at the end of the suspension period. Because forecasted test years are more complex and require more review, the suspension period mentioned earlier is 6 rather than 5 months. To calculate a revenue requirement, the first step is to determine a utility's allowable expenses. These include routine minor construction, purchase of equipment and materials, operational costs including maintenance, billing, customer service, and others, personnel costs such as salaries and benefits, the cost of major construction projects once they go into service, and any borrowing costs. Certain expenses are not allowed. Advertising for promotional expenses is excluded by law. Executive bonuses, employee gifts, and similar expenses typically are not allowed by the PSC. Charitable donations and club memberships are excluded. The PSC also has broad discretion to exclude any expense it deems unreasonable.
Unusual or one-time costs or revenue are excluded from the test year so that they do not distort the revenue requirement. They are instead accounted for separately and spread out over time. Unusually high storm recovery costs may be excluded. Revenue from asset sales also may be excluded. Note that operating expenses are recovered based on actual cost without markup. The final revenue requirement includes all of the allowable expenses and a calculation that sets the amount of additional revenue needed to meet financial requirements.
Certain utility expenses are not included in the revenue requirement and thus are not included in base rates. These include, for electric utilities, fuel costs above or below the amount included in base rates. These appear as a separate surcharge or credit on the bill. For gas utilities, the commodity cost of gas. It appears separately on the bill. Environmental compliance costs above the amount included in base rates for coal-burning electric utilities. These appear on the bill as a surcharge. Energy efficiency programs for some electric and gas utilities. Utilities may recover these costs through a surcharge. Surcharges to pay for assistance programs for low-income customers. Costs assessed by other entities, such as city or county franchise fees or local taxes. Once a revenue requirement is determined, the second step in the rate-making process is the rate design. This process allocates both costs and revenues over various rate classes, including residential, commercial, and industrial categories. As part of a rate application, utilities submit cost of service studies that allocate costs over the various rate classes. In general, larger customers have lower costs of service due to economies of scale. Thus, the cost of service typically is highest for residential customers. Rate design also examines fixed versus variable costs. Fixed costs are those that do not vary with consumption, such as meter reading or customer service. Variable costs are those costs driven by usage. The PSC uses cost of service analysis as a guideline, but rates are not required to be set strictly in accordance with the cost of service. Thus, large industrial customers, even if they pay lower rates than residential customers, typically pay rates higher than their cost of service would indicate. Conversely, residential rates may not fully recover the cost of serving those customers. The PSC typically does some rebalancing of rates in each rate case, both in terms of fixed and variable rates and allocation across classes. But those adjustments are done in small increments, in keeping with the PSC's long-standing policy of gradualism in moving toward fully balanced rates.
Now let's turn to an overview of the Big Rivers rate case, case number 2012-00535. Big Rivers filed its rate case in January. It carries a 2012 case number because Big Rivers filed notice of the upcoming rate application in December of 2012. The PSC suspended the rates until August. The length of the suspension was determined by the fact that Big Rivers is using a forecasted test period, one that looks ahead at the utility's revenue and expenses. A decision is due no later than mid-December, but could come several months earlier. Although Big Rivers is requesting additional revenue of $74.5 million, that figure would still leave the utility with less revenue than it has now. That is because Century Aluminum, which now accounts for about 40% of Big Rivers' total revenue, gave notice that it will exit the Big Rivers system in mid-August. Big Rivers has stated that it intends to respond to the loss of Century Aluminum as a customer by cutting operating costs that will no longer have to be incurred to serve Century. This could include closing a power plant. However, Big Rivers states that it will need $63 million to offset revenue from Century that has paid for costs that cannot be cut. The remaining $11.5 million of the requested additional revenue is needed to maintain the utility's financial stability, Big Rivers says in its application. Big Rivers estimates that the increased revenue, if granted in full, would add $24 to the average monthly bill for residential customers served by the 3 electric distribution cooperatives that both own Big Rivers and purchase power from the utility. That would bring the average monthly bill to about $150. The increase for residential and small commercial customers, known collectively as the rural class, would come as a pass-through of the Big Rivers rate increase by the distribution cooperatives. The other large industrial customers on the Big Rivers system would see a 17% increase if the Big Rivers request is approved, according to the application. Several matters that have been discussed publicly in connection with this case are not actually part of the case. This includes the recently filed contract between Big Rivers and Century that would allow the aluminum smelters to purchase power on the open market and have it transmitted to them via the Big Rivers system. This contract will require separate PSC review and approval before it can take effect. The financial impacts of the contract may, however, be considered in connection with this rate case. Furthermore, this case does not consider the impacts of the exit of the smelter in Seabury from the Big Rivers system. That facility, which Century recently purchased from Rio Tinto Alcan, is due to exit in January. Big Rivers has filed notice that it will submit a separate rate adjustment application to address the impacts of that event. 6 parties have intervened in this case and are participating in the pre-hearing development of evidence and in the hearing itself. They are the Kentucky Office of Attorney General, representing ratepayers as a whole, the Kentucky Industrial Utility customers, representing the non-smelter industrial customers, the 3 Big Rivers distribution cooperatives, and the Sierra Club, an environmental organization. The hearing in this case will be held beginning Monday, July 1, and is expected to last several days. It will be conducted at the PSC offices in Frankfort and is open to the public. It also may be viewed live on the PSC website, psc.ky.gov. Public comments will be taken at the start of the hearing.
Every rate case is different and reflects the unique circumstances of that particular utility at the time the case is filed. Rate case applications and related case files are available on the PSC website, psc.ky.gov. Here is how to make public comments. Including the case number in your comments will ensure that they are placed into the correct case file as quickly as possible. Here is who to contact to get more information about the PSC's rate-making process or any matter pending before the Public Service Commission.